of Kenyans and Nigerians who worked on board.
Mr. Otaji. Mr. Otaji. Mr. Otaji. It appears your network is.
My Lord, I'm hearing you.
I said this issue of balance of convenience we are conversing. Is
My
it
Lord,
not for I said the issue of balance of convenience we are conversing. Is it proper at this stage? You know, this is an interim order of injunction you are asking for. Is it not for the substantive application of the interlocutory injunction? It appears Mr. Otaji is okay.
My Lord, I didn't
check your.
Not get what my Lord is saying.
I said the issue of balance of convenience you are raising at this stage, is it not premature?
Oh, okay, my Lord, I withdraw that. I withdraw that.
To be for the main interlocutory application.
My Lord, I'll withdraw that until we will come back for the motion on notice, my Lord.
Yes.
My Lord, in this.
Yes, Mr. Otaji, your network is freezing you.
Before the. My Lord? Is my Lord hearing me?
Yes, I said your network is behaving.
It's fluctuating. Yes, my Lord, it's fluctuating. And I'm using MTN, you know.
Okay. Yes.
So, my Lord, our prayers before my Lord at this stage is for my Lord to exercise this discretion.
Yes.
As per.
Yes.
As per the prayers contained in the application, my Lord.
Okay.
We are most obliged. And for my Lord, that we should serve this order with the rest processes of this court. On all the defendants, my Lord.
Yes.
Most obliged, my Lord.
You're welcome. I will write to bench ruling.
As the court pleases, my Lord.
This is the ruling of the court.
God please this, my lord.
This is a motion ex parte dated 23rd day of July 2021, filed on the 27th day of July 2021, framed for an order of interim injunction restraining the first defendant, its beneficial and registered owner, freebies, servants, employees, agents, to maintain status quo ante bellum and refrain from selling, moving, and or whatsoever deal with the vessels MT ISU at Calabar Fort vicinity within the jurisdiction of this honorable court until the hearing of the motion on notice for interlocutory injunction. The motion ex parte was brought pursuant to Order 22, Rule 2 of the National Industrial Court of Nigeria, Rules 2017. The application is supported by a 39 paragraphs affidavit sworn to by one Idago Michael, the first claimant applicant in this suit. An affidavit of urgency of 6 paragraphs was also filed along with the motion ex parte. I have perused the processes filed in support of the motion ex parte, which comprise of the affidavit in support and the 2 exhibits attached therein, the affidavit of urgency and the written address in support of the said application. Mr. Otaji, counsel for the applicant, in oral adjudication before the court, relied on all the processes filed and adopted the written address as his argument. Counsel, in addition, relied on the case of Adewale Company Limited versus IBWA Limited Sufra as in support of the application. An application of this nature is calling for the exercise of discretionary power of the court. And like every other discretionary power, it has to be exercised judicially and judiciously, taking into consideration relevant factors that will enable the court to exercise its discretion one way or the other. From the affidavit evidence, the prayers being sought from the court, the substantive suit, the claimant in the substantive suit, the claimant are seeking for the payment of their wages for services rendered while on board a vessel called MT ISO, when the claim, which is a claim, is now at Calabar Port vicinity. The law is well settled that the purpose of granting an interim order of injunction is to temporarily stop or prevent disposal, dissipation, or annihilation of the race that is the subject matter of dispute. This is only done in a situation of extreme urgency where the dependent involved could not be served with the processes, with the originating processes, and the motion on notice commencing and the motion on notice for the application for interlocutory injunction. See the cases of Saraki versus Kotoe, reported in 1994, Nigerian Criminal Report, Part 143, page 144. See also Obeya Memorial Hospital versus Attorney General of the Federation, reported in 1987, 3 Nigerian Criminal Report, Part 60, page 325. It is clear to me from the authorities on the grant or refusal to grant an interim order of injunction that an order of interim injunction is not granted as a routine matter or as a matter of course for the asking. The order being an equitable one must be based on hard matter of law and facts, on hard matter of law to be considered in the light of the facts of the case presented before the court. The affidavit in support and the affidavit of urgency are very scanty on the facts are very scanty. They did not disclose urgency or need to exercise the discretionary power of the court to grant the order of interim injunction. This is because for an order of interim injunction to be granted, the applicant must establish or show to the court that the case, the order is an urgent order that has to be made because the party, the defendant, could not be reached to be served with the processes of the court. The affidavit of the applicant did not disclose any difficulty of serving the defendant with the originating court processes in this matter, or the motion on notice for interlocutory injunction. There are also absence of abatement in the affidavit showing the date the vessel in question, MT ISU, is to leave or sail out of the jurisdiction of this court. In the circumstances, I am of the view that this is a good case in which the defendant deserves to be served with the originating processes and the motion on notice for interlocutory injunction for them to react to the fact deposed to in the affidavit, for the court to consider and weigh the evidences of the parties and see where the pendulum will tilt and consider whether to grant or refuse the order of interlocutory injunction. I am not convinced from the facts deposed in the affidavit in support of the motion ex parte and the affidavit of urgency that there is an appropriate this is not an appropriate where an interim order of injunction can be issued without hearing the defendant. In view of the foregoing, the order of the court is for the defendant in this case to be served with the originating court processes commencing this suit, as well as the motion on notice for interlocutory injunction. The parties in this suit are also ordered not to engage in any act or do anything that will jeopardize the hearing of the motion on notice for interlocutory injunction, or to do anything that will in any way negatively affect the subject matter in dispute. In view of the fact that today is the last juridical day on which this court is to sit in this legal year, I shall adjourn the motion for interlocutory injunction to the day when the court will resume after its vacation. That is 28th day of September 2021. The case stands adjourned to 28th day of September 2021 for hearing of the motion on notice for interlocutory injunction. This order shall be served on all the parties in this case. That is the order of the court.
The court pleases. We're most grateful.
My lord.
Yes.
I wish my lord a happy vacation.
Thank you very much. So the order will be served along with the other processes. It will be served along with the other processes.
As the court pleases, my lord. We'll go with the order. We'll apply for submission of the order and then serve it, attach it to the other ones.
It's all right. You are welcome.
As the court pleases, my lord.
Yes, Registrar, you were to say something.
Yes, my lord, Yes, the 28th of September is not convenient. All matters on that date were moved.
It's because of the nature of this case. That's why I want to fix it on that day.
Okay, my lord.
Just leave
Yes,
it.
my
It's
lord.
only this day we will hear on that day. It's
Okay,
going
my
to be
lord.
virtual sitting.
Yes, my lord.
It's going to be virtual sitting. But make sure
Okay, my
you
lord.
immediately serve the originating court processes and the order on the defendants,
Yes, my lord.
so that they will know what they are supposed to do, not to tamper with the subject matter.
Yes, my lord.
Thank you very much, counsel.
I'm most obliged, my lord.
They
I
will
wish my
serve.
lord is successful and a
Thank you.
happy vacation
Thank you
and
very
a good
much.
rest. Thank you.
Okay. Have a nice day. The administrator,
my
you
lord.
can discontinue with the sitting.
Yes, my lord.
My lord? Miss Madu. Miss Madu.